This lesson will focus on intellectual property. Within this lesson, we will discuss copyright law, patent law, trademark law, as well as right of publicity. Within the U.S. Constitution, Congress was granted the power to enact intellectual property laws. And that is where we will find copyright law, trademark law, right of publicity, and patent law. These laws are designed to protect those engaging in marketplace competition and reward the creators of intellectual property for the fruits of their labor with ownership rights. These ownership rights are treated as personal property that can be licensed, sold, loaned, or given to others. Let's first start by talking about copyright law, which came about in 1909 with the United States Copyright Act. As you will see on this slide, the United States Copyright Act was enacted to protect the work of authors from the unauthorized use of their copyrighted materials. This provides a financial incentive for artists to produce, therefore increase the number of creative works available in society. So a good thing. The purpose of copyright law is to protect those who have put time and energy into a creative project. So copyright is a system for protecting the original works of authorship that is fixed in any tangible medium. Therefore, based on this definition, there are two fundamental criteria for copyright protection. The copyright must be original, so it must be new. It cannot be a derivative of someone else's work, and it must be in some tangible form that can be reproduced. Copyright protection will exist as soon as the work is in some fixed form. So in print, a CD, DVD, motion picture, canvas, sculpture are all different examples. Examples that we see on this slide that may have copyright protection or may receive copyright protection is the Sunday Night Football theme song is a choreographed musical work. Sports Illustrated magazine is a literary work. SportsCenter broadcast is a dramatic work. And then this infamous picture of Brandi Chastain from the 1999 Women's World Cup. That photograph would also receive copyright protection. Let's dive in a little bit more to what does and does not receive copyright protection. As you can see on this slide, there are 8 categories of copyright protection, which include literary works, musical works, dramatic works, choreographed works, photographs, graphics, sculptures, motion pictures, any sound recording, architectural works. So there are a number of categories that demonstrate works that are original and in a tangible form that can be reproduced and therefore should receive copyright protection. Also on this screen, you will see what is not protected. So copyright protection does not extend to an idea, procedure, process, system, method of operation, concept, principle, discovery, any of those, regardless of the form in which it is described, explained, illustrated, or embodied in such work. Now, these ideas, procedures, those might be able to have patent protection, or concepts might be able to have trademark protection, but they do not receive copyright protection. Now, specifically the categories of works that don't receive copyright protection, you can see on this screen. So it will include any type of government document or work in the public domain. So these are works where copyright really isn't requested because it's a work that's in the public domain and therefore available to the public to use. Works that are not original obviously does not meet that fundamental criteria for copyright protection. So any type of standard work such as a calendar, charts, tables, tape measures, those are examples of works that are considered standard and not original. Blank forms used to obtain information also do not receive copyright protection. So any type of waiver or contract that we've talked about in class would not receive copyright protection. This one is very specific to our industry: athletic competitions and games. These are not copyright protected because if plays were copyrighted, it would impair the underlying competition within our leagues. So you can copyright a broadcast of a game. However, you cannot copyright the underlying games and the plays within. Additional things that cannot be copyrighted are works where authorship is small. And so you'll see in the upcoming slide that copyright protection is pretty extensive in terms of how long the author has copyright protection. And so the work needs to warrant that level of protection. So it only extends to works that are considered significantly creative, that there was substantial labor to produce that intellectual property. So examples of works where authorship is small would include slogans, titles, names, typographic, ornamentation, lettering, coloring, a lot of what we see in trademarks. You can't copyright it, you can trademark it. And then also facts and raw data cannot be copyrighted, such as players' game statistics that are used in fantasy sports. Those cannot be copyrighted. So let's discuss what specifically are the rights of the copyright owner. So ownership will initially vest with the author or the creator of the work. However, there are a few unique situations where the ownership may be licensed or where the creator of the work is actually not the owner of the work. So let's talk about that. In a work for hire situation, the work is actually prepared by an employee within the scope of their employment. And so the owner of the copyright in this case is the employer of the person for whom the work was prepared. So that is a unique situation that you should be aware of. If work is created within the scope of one's employment, copyright ownership goes to the employer. One unique situation I thought was interesting is that players cannot claim ownership in the copyright of televised games because the players are working for the team. And so that is why it's the team who engages the league in regards to broadcast rights and revenue. So that would be an example of a work for hire. And then licensing is another unique situation. With licensing, the owner of a copyright may authorize others to use their copyrighted materials. So these licenses should be a legal written contract that states the protected rights of the owner and the protected rights of the person receiving the license. When thinking about licensing in the different categories of copyrighted works, I'll give you a few examples. So for music and performance, all musical scores that are performed by bands should be purchased and can be licensed from performance rights agencies. Public performances, those also must be licensed. When it comes to broadcast, so radio or television, even though it is considered live, so broadcasting a sport event is live, it still is eligible for protection because it can become fixed in a tangible form and reproduced. So even though transmission is live and not yet fixed, the broadcast can be protected by copyright law. And so a public establishment like a sports bar that wants to transmit cable or pay-per-view broadcasts must have a license. So once again, even though the event is live, that broadcast can be copyrighted within 3 months after its first transmission. So regardless, a sports bar is still going to need to get a license to transmit that broadcast. The only exemption we see here is for home use, which basically means that you can watch TV and you can watch these sports games without needing a license. So those are a few examples of where we have licensees in sports and in different areas of copyright. With the right of a copyright owner, so as you see on this slide, a copyright owner has exclusive right to copy, reproduce, distribute, publish, perform, or display their work. Basically, they have exclusive rights to their work. However, there is one exception that I wanted to share, and it is called the fair use exception. So the fair use section of copyright law was passed to strike a balance between the copyright monopoly that an owner receives and the greater interest of society. The fair use doctrine will enable the public under specific circumstances to make use of a copyrighted work without infringing on the rights of the owner. So for purposes such as criticism, comment, news reporting, teaching, scholarship, or research, the public can use copyrighted work without fear of infringement. A primary motivator for the passage of the fair use section was the use of copyrighted works for educational purposes. So all of the graphics that you see in these PowerPoint slides are exempt from copyright infringement due to the fair use educational purpose of this lesson. Google is actually another example of an agency that claims fair use. And as previously mentioned, copyright has pretty extensive protection when you consider the protection that is awarded for patent law and trademark law. The copyright protection that an owner will receive lasts 70 years beyond their death. So they have rights to their intellectual property for their entire lifetime and 70 years beyond the death of their author, beyond their death. It passes based on the will, it would pass on to another person as personal property after the author's death. And then for works made for hire or anonymous works, in total, the protection is 95 years. But substantial protection, this is a very long time, which we'll notice is a little bit different for the other laws. So if there was a violation of the Copyright Act, which basically means that someone is using a copyrighted work without the permission of the owner or without a license, then there is potential for copyright infringement. And when there is copyright infringement, the courts will look at a number of factors because some use of copyrighted work, such as fair use, is actually protected. So they're going to look at these 4 factors. They'll look at the purpose and character of the use, whether it's being used for commercial purposes or for educational or nonprofit purposes. Commercial, that's illegal. Educational, nonprofit, that is permitted under the fair use exemption. They will look at the amount and substantiality of the portion used in relation to the copyrighted work as a whole. So for example, once again, when thinking of the educational context, how much of the work are you using? It's okay if I provide you a book chapter from another textbook that's not a part of this class, but I can't completely provide you with the entire textbook free of charge if you would have purchased it on your own. So how much of the intellectual property is being used in this case? Smaller proportion, acceptable. Large proportion, that is a major injury to the copyright owner. And then the courts will look at the nature of the copyrighted work. Is it in the public domain or private domain? Is it unpublished, published, factual, creative? That will all determine the degree of infringement, as well as the effect of the use upon the potential market for or value of the copyrighted work. So for example, once again, if I gave you one book chapter versus the entire book for free, that would really impact the income of the copyright owner. So how much are you impacting the income of the creator by your use of the mark? Those are a few different factors that the courts will examine for copyright infringement. And if the defendant is found to have infringed upon the plaintiff's copyright rights, then there are a number of remedies that can be employed. Injunctive relief would basically be a mandate that the use of the copyrighted work stop. There can be monetary damages for the income that was lost. The defendant can be asked to destroy any of the infringing materials, and they could potentially also face criminal penalties. So there could be some pretty harsh penalties for copyright infringement. Next, let's shift to patent law. So the Patent Act of 1952 states that a patent is obtained by whoever invents or discovers a new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement of the above. So I hope you notice that while under the Copyright Act, things such as ideas, procedures, processes, systems do not get copyright protection, they may get protection under patent law, any invention or discovery. Within the sport industry, the majority of patents received in sport have been for equipment, such as the pitching machine design that you will see on this screen. Originally, patents were primarily for inventions. However, the courts have began to allow patents for business methods, which in sport we have seen as players' moves. It's been super interesting. As you'll see on this slide, Shaun White's double McTwist 1260, which is a really insane snowboard trick that he invented back in 2010 at the Grand Prix. He has patented that move. Other moves that have been patented are Dale Miller's grip on the golf club for his putt. Nolan Ryan patented his pitch. The trouble with patenting sports moves is that it's pretty difficult to police and then to enforce your patent, because you have to be mindful of who else is using that move. A patent is not allowed for laws of nature, natural phenomenon, and really abstract ideas. So that's just one caveat with a patent. The purpose of a patent is to allow the holder of the patent to essentially have a monopoly on the way the invention is used for a period of 20 years. So if we compare the protection under copyright law to patent law, copyright law is 70 years past the owner's death, whereas patent law is 20 years that begins on the date that you applied for the patent. A patent is infringed upon when someone without authority makes use of, offers to sell, or sells any patented invention within the United States or imports it into the United States. And if you are found in violation of the Patent Act, you can face damages for that violation. Let's next shift to trademark law. Trademarks are governed by the Trademark Act of 1946, which is more commonly known as the Lanham Act. Under the Trademark Act, there are 3 distinctive categories that exist under the umbrella term trademark. I think most of us, when we think of trademark, we think of the trademark category, but there are actually 2 other categories for us to consider. So trademark, that category identifies a seller's good and distinguishes them from those manufactured or sold by others. Nike is an example, as well as all of those different examples of trademarks above. So IBM, Coca-Cola, Ford, John Deere, Levi's, Barbie. These are all examples of any work, name, symbol, or design that is intended to distinguish one's goods from another. However, there are 2 other categories for us to be aware of. Whereas a trademark identifies the source and quality of a product, a service mark identifies the source and quality of an intangible service. So for example, the NCAA, as it stands for events and services related to the National Collegiate Athletic Association, would be considered a service mark. Now, if the NCAA is also printed on apparel, for example, it could also constitute a trademark. So these categories are based upon the intent of the mark. What is it intended to accomplish and distinguish? So service mark distinguishes services, and then a collective mark is used to indicate membership. So membership in a union, an association, or any other organization like Major League Baseball, the National Football League Players Association, the Big East Conference. And once again, a collective mark may also be used in combination as a service mark or a trademark. It's really just based upon its intended purpose. When thinking about the specific mark of a trademark, service mark, or collective mark, trade dress is the term used to describe the overall appearance of the mark. So the color, shape, size, logo, and any other characteristics. It's important to identify the distinctiveness of trade dress because it will inform the level of protection that is given to the trademark. So there are 5 different categories of trade dress for us to consider. And we'll start with the weakest categories. Generic marks are considered common descriptive names of objects. These generic marks receive no trademark protection because they refer to the name or class of the good or service. They're so common that they're not indicative of the source of the good or service. So examples might be Kleenex, Jell-O, aspirin. A recent case that I find fascinating is, for example, Ohio State University tried to trademark the word "the." I don't know if you have seen apparel that just has the word "the" in scarlet and gray colors, and we all know that it represents Ohio State University, but the US Patent and Trademark Office did disagree here. They rejected the application because they said specifically the word "the," just "the," that alone cannot function as a trademark because the word does not distinguish its good from any other, just the word "the." they disagreed with us. So that would be an example of a generic mark. A descriptive mark will identify a characteristic or quality of a good or service. Now, these marks will only receive trademark protection after they've obtained secondary meaning, which means that they have public recognition and widespread use, so much so that the public actually is able to recognize the source of the good or service based upon that mark. Examples of descriptive marks might be Louisville Slugger, British Airways, university color schemes have also received trademark protection under secondary meaning. So scarlet and gray has received trademark protection. And then there are suggestive marks, which require some imagination, thought, and perception to reach a conclusion as to the nature of the goods. They like hint at the characteristics of the goods or service, but require some imagination to truly understand the mark. So Under Armour, Microsoft, North Face, Hot Pocket, those are the examples of suggestive marks. And then we have fanciful marks. A fanciful mark is actually not a real word in the English language, but it's invented to be used as a mark. So Codex or Clorox would be fanciful. Adidas, Exxon are all great examples of fanciful marks. And then arbitrary marks apply a common English word in an unfamiliar way. So Dove, Apple, Puma, I think is actually a bit more suggestive, but Apple's a great example of an arbitrary mark. When considering the strength of the mark, the strongest marks are arbitrary or fanciful marks that bear no direct relationship to the product or service itself. So they will receive the greatest amount of trademark protection. Whereas descriptive and generic marks are considered the weakest marks because they lack that connection to or ability to distinguish the product or service. And so those marks often do not receive trademark protection. When considering the rights and ownership of the trademark owner, in order to create ownership rights, the trademark owner must be the first to use the mark in trade and make continuous uninterrupted use from then on. Once the trademark is used, consumers can rely on it to identify and distinguish the owner's particular goods or services from others. Federal registration for a trademark, which is indicated by an R with a circle, is not required to establish common law trademark rights or required to begin using a trademark. If you have an unregistered trademark, it is identified with a TM, which you see on this slide next to the Starbucks trademark. An unregistered trademark still gives the owner rights to the trademark as long as that owner is the first person to use the mark and has continued to use that mark. However, there are some benefits with federal registration as it provides constructive notice to others that you own this mark. You have exclusive rights to this mark. So it announces to the world, hey, don't use this mark, it's mine, basically. And it gives evidence of the mark's existence. If you wish to obtain a registered trademark, you would need to file a formal application with the Patent and Trademark Office, and that registration would last for a period of 10 years. I strongly encourage any and all sport organizations that are creating a trademark to ensure that their logo, design, or other insignia is not already registered as a trademark, to make sure that you do not become liable for trademark infringement. So you can look up trademarks through the federal registered trademarks through the United States Patents and Trademark Office. Now, one other thing I wanted to note on this slide is that trademarks include a number of things. It can be a slogan, it can be a graphic, it can be a specific name. So it can be a color scheme. All of that can be trademarked. I'm going to switch my screen to show you how you could look up registered trademarks. So if you go to the United States Patent and Trademark Office, you can search for all registered trademarks here. So if you select search trademark database, you can go to the trademark electronic search system. And this is where you would search. Now, if we wanted to do a basic word search, so you can search for a word, you can search for design, you can search for both. We'll start with a basic word search. You would type in the term that you wanted to search for. So I was looking up a few earlier today, and we can look up scarlet and gray for Ohio State and submit our query. And we see all trademarks that are currently live or dead. Dead meaning that they no longer have protection. Let's go to this first one that is live. And we'll see the registered trademark below. So as you can see, The Ohio State University is the owner of this scarlet and gray trademark for the production of hats, shirts, and t-shirts. And this is a standard character mark. We filed this registration back in 2006. And so, gosh, it looks like we would need to get an updated application in here to keep this trademark live. But it gives you also the type of the mark. So this would be a trademark used to distinguish goods, which makes sense because of the hats, shirts, and t-shirts. But it gives you some information. And then, oh yeah, okay, this is good. Ohio State's on top of it. We did renew it back in 2016. So now we'll have this trademark through 2026. And it is live and tells the whole world that we have exclusive rights to scarlet and gray. So when considering what types of marks you might want to trademark, there are a few categories that do not receive trademark protection. And in addition to the generic marks that were previously discussed, if a mark consists of anything that is considered immoral, deceptive, or scandalous, or may disparage or falsely suggest a connection with people, institutions, national symbols, bring them into contempt or disrepute. Basically, if it's a bad mark, okay? As you'll see on the table on this slide, I apologize, it's a bit crass, but it's a great example of trademarks that have been refused for being immoral, deceptive, or scandalous. So examples such as Quran, which they wanted to use to sell alcoholic beverages, that was rejected. And then trademarks that include the flag or coat of arms or any type of insignia specific to the United States or any of the states and foreign nations associated with the United States, such as the graphic on this slide of the mascot holding an American flag, that would also be refused. Understandably, any mark that is someone else's name or their portrait, particularly of living individuals, that would be rejected unless you have expressed written consent from that person. That just makes sense. That's a right of publicity issue, which we'll talk about. And then lastly, a mark that consists of a already registered mark in the Patent and Trademark Office. That is essentially a trademark infringement, and you will be denied registration if that mark already exists. So it's good to do your due diligence, check out that trademark electronic search system and figure out, is that mark already registered? So the example that we see on this screen is Coffee Rocks trying to trademark a graphic very similar to Starbucks coffee, which already has a trademark. So let's dig a bit deeper into trademark infringements. So this happens when someone is using a mark that is unauthorized. So trademark infringement, like I said, it's when a defendant is using the plaintiff's trademark without their authorization, without a license, illegally. So the cause of action is trademark infringement, and the plaintiff would have to prove first that the mark is valid, which is why registering your trademark is really critical. You need to prove that you are the first to create and use the mark, that you have used the mark continuously, and being able to prove registration also is a great way to prove that your mark is valid and protectable. And then second, the plaintiff would have to prove that the defendant's use of the mark is likely to cause confusion, mistake, or deceive consumers as to who the true source of the mark is. So this is the first trademark infringement cause of action that you could use, is confusion. When the plaintiff is trying to prove that this illegal mark is going to cause consumers confusion about who the true source of the mark is, the courts will consider these factors of confusion. So they'll look at the strength of the mark, which I love this graphic because it really compares confusion, or these factors of confusion for different trademarks. So for example, Nike is an exceptionally strong mark, so likely to not have confusion there. They'll examine the similarity between the marks. So for example, the Adidas graphic and the Herbalife graphic, quite similar. However, Adidas is a really strong brand and it's a very different product. So unlikely to cause confusion there. They'll look at the similarity between the products and the marketing channels used to sell them. So are the marks referencing a similar product or service, or completely different product or service? Because that will also change basically the level of confusion there. And then they'll also look at the likelihood that the trademark owner will expand their use of the mark in future products, because if they want to expand, then there's potential for future confusion. They'll also look at evidence of actual confusion. So is there any data to support the fact that consumers are confused between these two different marks? They will look at the defendant's good faith intent in adopting the mark. Was the defendant aware of this other mark and continue to use it? An issue that honestly I often see is high school athletic programs using mascots that are very similar to collegiate and professional sports teams. And they were probably aware of those trademarks that existed. And then the courts will also look at the quality of the defendant's product, because if they are very different, so on the screen you'll see Under Armour and Uncle Martian, they were selling products in the same relevant marketplace, and Under Armour is a very strong brand. Uncle Martian was a very weak brand, and not only could cause confusion in the marketplace, but could really take advantage of Under Armour's brand recognition. So that was a very clear infringement there. And then they'll also look at the sophistication of consumers, in that are consumers able to distinguish the difference between the trademarks. So they'll look at the totality of all of those factors to determine whether there was actually confusion between these marks and therefore trademark infringement. Here are a few additional causes of action that a plaintiff could file for a trademark infringement. So the first one was specific to confusion. The next one is referring to counterfeiting. So another form of trademark infringement is counterfeiting, which is often known as piracy. Counterfeiting is an intentional effort to produce products that reproduce a genuine trademark without any license or permission. The Lanham Act allows manufacturers, sellers, and producers of goods and services to prevent competitors from using any counterfeit, copy, or imitation of their trademarks in connection with the sale of any goods or services, because once again, this is likely to cause confusion, mistake, or deception. There actually was a act that came about after the the Lanham Act, which is the Trademark Counterfeiting Act of 1984. And this specific act provides that whoever intentionally traffics or attempts to traffic in goods or services or knowingly uses a counterfeit mark in connection with goods or services will be fined or imprisoned. So there actually is another act that came about specific to counterfeiting. And the picture that we see on this slide is we often see a lot of counterfeit materials, specifically apparel, when it comes to major sporting events. And this was back in 2018, the FIFA World Cup. This was one of the counterfeit materials that was confiscated by the US Customs and Border Protection officers in El Paso, Texas. They intercepted nearly 114,000 pieces of apparel, specifically jerseys for the World Cup soccer. These knockoff jerseys use the names and logos of the national soccer teams of Mexico, Germany, and Brazil. So we see major confiscations, such as another example, the 2018 Super Bowl. US Customs and Border Control and their anti-counterfeiting operations were able to confiscate over $15 million worth of apparel in the black market for NFL goods, which I think is just crazy. Another trademark infringement complaint is dilution. Dilution is law protects the distinctive quality and selling power of a trademark, even if consumers are not actually confused by a non-trademark owner's use of the mark. It's all about, is the quality and selling power of the trademark diminished? So dilution is a claim that would be brought by owners of famous marks who believe that another party is using a similar mark that can diminish or weaken the association that consumers make between their mark and their product and service. The major factor that courts will consider is harm to the public due to confusion. The example that we see on this slide is enjoy cocaine. I thought that was kind of funny. So there was a lawsuit between Coca-Cola and Gemini Rising for using this particular logo. Gemini Rising is a marijuana company. And so in this particular case, they claim dilution by tarnishment. So that's a little bit different. Dilution by tarnishment involves the use of inferior goods that uses a confusingly similar mark to a famous mark and thus lowers the esteem of the famous mark through its association with inferior goods. This also applies where the goods of the infringing mark are somewhat unsavory, such as drugs, and not keeping in alignment with the image of the famous mark. So that was just one example of dilution. And we also have an act that was passed specific to dilution. So the Federal Trademark Dilution Act of 1995 creates an actual cause of action for dilution. And then another cause of action is unfair competition and false advertisement. Unfair competition can involve any activity where one party attempts to deceive or mislead consumers by using the trademark of another to give the consumer the mistaken belief that the product of the infringer is actually the product of the true trademark owner. And then false advertisement is another one, which we have an example on this slide. This is when one party uses commercial advertisement or promotions to misrepresent the nature, characteristics, quality, or origin of the product. This might be when brands will use faulty data to try and deceive consumers. On this slide, I thought this was an interesting case with Powerade. So Pepsi sued Coca-Cola for false advertisement, as well as trademark dilution and unfair competition. They just listed everything because in Coca-Cola's Powerade Ion for sports drink ads, they allegedly made the false claim of being the complete sports drink. So in the process of these ads, they claimed that their competitor, Gatorade, produced by Pepsi, is missing 2 electrolytes and therefore is incomplete. To be a complete sports drink, you have to have 4 electrolytes. So they claimed false advertisement, but they've been battling it out for forever. There are a number of trademark defenses that a defendant can use if they are sued for trademark infringement. The first is laches. So laches bars relief to those who wait to file a claim. Basically, you were just negligent in not filing a claim in a timely manner. The example that you see on this slide was a lawsuit between the Brooklyn Brewery Corporation and the Brooklyn Brew Shop. What I thought was really interesting is that the Brooklyn Brewery Corporation, which had the first trademark, became aware of the brew shop in 2010, and these two parties actually began collaborating. So between 2011 and 2015, they started offering co-branded beer making kits, which you see on this slide, held promotional events together for their kits, and they appeared together at beer related events. So they are very aware of each other and are coexisting. But after 2015, when their collaboration ended, all of a sudden, the Brooklyn Brewery Corporation sues the brew shop for a trademark infringement for using marks that confuse the marketplace. I just think it's ridiculous. They coexisted. So anyways, that was an example of laches because the court threw that one out since Brooklyn Brewery Corporation was aware of this other mark all along. Another example of a defense is cancellation. So a mark can be canceled if it becomes common or generic. So for example, Kleenex may have originally had a registered protected mark, but if that mark eventually just becomes a common generic association with that general product, then that registered mark can be canceled. If it's offensive, so those registration or those marks that were any marks that can be refused either will not get trademark protection or they can later be canceled, which we'll talk about with the Washington Redskins in a minute. And then also any mark that is successfully challenged. So potentially there were 2 marks that received protection. However, one was able to prove that the other mark is infringing upon their mark. March Madness is an interesting one, an interesting case we'll talk about in regards to it originally was not used by the NCAA. And so that was challenged. So a mark can be canceled for a number of reasons. There's also abandonment. Once again, for you to receive trademark protection, you need to be not only the first party to use the mark, but you must use that mark continuously. So you have to actively use the mark for it to remain valid. And it would be considered to be abandoned if it's not used for a long period of time. The courts find that about 3 years is evidence of abandonment. So if it's abandoned, it's considered discontinued, and therefore the owner no longer receives protection, and it's fair game. And then another example is fair use. So fair use when it comes to trademark is when a party is using a mark in good faith only to describe the goods or services involved. So they're not intending to use someone else's mark. They just happen to be describing their goods or services in their advertisement. So the example that you see on this slide is Gatorade. They were sued by a company called Sport Fuel. So if you look at the advertisement, the Sports Fuel Company, I could see why Sports Fuel would sue Gatorade for this. However, in their argument, they argued fair use, saying that their use of the term sports fuel in its slogan, Gatorade, the Sports Fuel Company, was not intended to use sports fuel's mark. It was merely intended to describe the type of product it sells, not signify the source of the product. And then luckily also Gatorade is a really strong product, and so it's likely to not cause confusion in the marketplace. And then lastly, another trademark defense is parody. So parody of a trademark is considered not an infringement because there's not a likelihood to cause confusion. But when it all comes down to it, trademark infringement really is looking at, is there going to be confusion in the marketplace between who is the true source of these goods or services? And I love the example on the screen, the North Face versus the South Butt cracks me up. So this college student, Jimmy Winkleman, created South Butt intentionally out of parodic respect, is what they said, for the North Face. And so this would be an example of someone trying to make a mark that is a parody. Some marks have been able to successfully use this defense. This one, we're not actually sure what happened because the case settled out of court, but I thought it was a funny example of a parody. A few other trademark defenses are disparaging remarks. So as previously mentioned, a disparaging mark will not receive a registered trademark. However, whether it's disparaging or not may occur later down the line. So for example, the Washington Redskins was a registered trademark. However, the courts have now determined that this particular mark is disparaging to a substantial composition of American Indians, and therefore is now, so it's disparaging now and no longer will receive trademark protection. Another defense is a disclaimer. This one is, I think it's a bit weaker of a defense, but if a trademark infringer, so the defendant, is able to argue that they placed a disclaimer alerting consumers that the product or service is not from a specific source, does not contain certain attributes or features, it protects them from liability for infringement. But courts have generally found that disclaimers that are not prominently featured on products are just of limited value. So it's a pretty weak defense. And then there is licensing. So a license, as previously mentioned, is a written document where the trademark owner grants another party the right to associate their business or product with the mark of this trademark owner. So you can, Ohio State is a Nike school. That's a great example of a license. Now, where the license is held is usually at the highest entity level. So for example, the NFL, NBA, NHL, MLB, all of those sport leagues have a licensing division to manage all of their trademarks with vendors who manufacture and sell products to consumers. And then they work with the individual teams to determine revenue share. The NCAA protects their intellectual property for trademarks and service marks, and then license these marks to the university. Universities handle their marks. You see where we're going with this. And then there is ambush marketing. Ambush marketing is an interesting one. So with the rights fees for major events like Super Bowl, Olympic Games, costing several millions of dollars, official sponsors want to ensure that they are the only company that is going to be given exposure associated with the particular event. However, ambush marketing still happens. It's a big issue. It's when companies try to weaken or attack competitors' official association with a sports organization or event by using advertising and promotional campaigns designed to confuse consumers and to misrepresent the official sponsorship of the event. I don't know if I would say it's an intentional attack, but it is definitely a way or a strategy to try and associate yourself with an organization or event without actually having to pay the millions of dollars for the sponsorship rights. The example that we see on this slide is from the 1996 Olympic Games. So interestingly enough, Reebok was the official sponsor for the Olympic Games, and they paid $50 million back in the 90s to become the official sponsor. However, Nike was quite sneaky in trying to associate with the game. So instead of paying for an official sponsorship, they engaged in some ambush marketing, where they gave Michael Johnson these infamous gold shoes, which were then later shown on Time magazine. They opened a Nike Center right beside the Athlete Village. They distributed flags to fans so that the swoosh logo would be in full view over the televised events. So that was some pretty sneaky ambush marketing, but often competitors can use it as a defense and claim commercial free speech. And then the last area of intellectual property I wanted to briefly review is right of publicity. So this is the right of everyone to control the commercial use of their identity. Right of publicity recognizes the economic value of an individual's identity. In particular, we're seeing this with celebrities, professional athletes, even some college athletes, and it prevents unjust enrichment of those who usurp the identity of another. So when talking about right of publicity and what a person has rights to, generally it is a person's image rights as it relates to their name or their likeness that they're trying to protect. So any visual representation or photograph of that person, their nickname, a drawing of that person, a celebrity look-alike, even vocal idiosyncrasies, anything that depicts this individual, well, that individual should have the right to determine how it is used and to gain all economic value from their identity. So this right really evolved mostly for entertainers, celebrities, and public figures who were either facing misappropriation of their name, which is the unauthorized, improper, unlawful use of their identity for a purpose other than for which it is intended, which honestly, it's usually for commercial purposes. So these public figures were experiencing unauthorized use of their name, image, and likeness, real big issue in college athletics right now, as well as privacy violations because they didn't have control over their identity. For a misappropriation right of publicity complaint, the plaintiff would have to prove that the defendant is using the plaintiff's identity, that there was a misappropriation in which the defendant was gaining some type of economic advantage for using the plaintiff's name, image, or likeness. There wasn't consent, so it was definitely unauthorized, and it resulted in injury. Typically, for a right of publicity complaint, we're focused on economic injury, not psychological injury due to the invasion of privacy. The examples that you see on this slide are major cases in sport. Brown versus Electronics Arts, O'Bannon versus EA Sports, a lot of lawsuits against EA Sports for the use of athlete avatars in their sports video games without those athletes' consent. That has been a really major lawsuit, as well as Jordan versus Kyodan Sports. They are citing trademark infringement, but it is a right of publicity issue because Kyodan Sports is using the image as well as the name of Jordan, because Jordan in Chinese is Kyodan, to try and sell their products. So those are just a couple of examples. And then for a right of publicity complaint, there are a few First Amendment defenses that are available to the defendant. Because the First Amendment is designed to protect the dual freedoms of speech and the press, the courts do allow the unauthorized use of an individual's name or likeness when it is used for the dissemination of ideas and information or for other cultural purposes. So the courts will weigh one's right of publicity against another's First Amendment rights and try and balance those out. But really, it's just intended for dissemination of ideas, information, what is of benefit to society. If an individual's name, image, or likeness is used for commercial purposes where the defendant experiences economic gain from using the plaintiff's name, image, or likeness, that is not protected. So that would be a very easy infringement case. However, let's talk about these defenses. The newsworthiness defense permits the media to use the unauthorized likeness of celebrities or anyone of interest in connection with a news item about the person. So basically, it needs to be a matter of public concern and interest when you are using the individual's name, image, or likeness. An athlete's performance in major sport events has found to constitute matters of public interest, such as the Cubs were winning the World Series, as we see on this slide. Another defense is incidental use exception. And this is when advertisements incidentally use an individual's name, image, or likeness for advertising purposes. So for example, photographs that reproduce previous magazine or newspaper issues to illustrate the quality and the content of the magazine or newspaper rather than the specific athlete displayed. That would fall under the incidental use exception, such as this advertisement for ESPN's magazine. And then there's the parody defense. Generally, parodies that are used in traditionally non-commercial mediums, so newspaper, magazine, television program, book, or movie, will be granted First Amendment protection. However, once again, anytime it's used in a commercial context, they usually do not receive First Amendment protection. The example that you see on this slide is in South Park. They often have professional players being represented, but typically the courts just don't see there to be an issue because there isn't cause for confusion. And then the last is transformative use, which occurs when an artist embellishes the depiction of a personality rights holder so much so that the goods containing the depiction of this famous person is now associated with the artist's rendering, more so associated with the famous person. Let me say that a little bit more simply. The individual's image is so transformed that when you see this image, the consumer primarily thinks of the artist and no longer that individual who was the source of inspiration. So it really depends on how transformative these images are. We mostly see this in the arts. Famous example on the screen is Andy Warhol's Marilyn series was found to be so transformative enough to warrant First Amendment protection. So you see that piece of art and you think of Andy Warhol. However, other lawsuits such as Keller versus EA Sports, once again, all the lawsuits against EA Sports, EA Sports tried to claim transformative use in their video games, but they were unsuccessful. So that was a comprehensive overview of intellectual property. I encourage you to dive a bit further by clicking on this link and looking up your favorite brands to check out the details of their registered marks.